Welcome to Sriram's IAS. Today's lecture is on the topic related to Article 14. Equality before law and equal protection of law. Okay, so Article 14 states equality before law and equal protection of law. Okay, so now let us discuss what does Article 14 say. Article 14 says that the state shall not deny to any person. The state shall not deny to any person equality before law and equal protection of law. Okay, the state shall not deny to any person. Now, this provision that is equality before law and equal protection of law is applicable, or it confers rights not only on the citizens but also foreigners. Okay, so this provision confers rights not only on the citizens but also foreigners, and the term person here includes legal person, that is statutory corporations, companies, registered societies, etc. Okay, so Article 14 says that the state cannot deny to any person equality before law and equal protection of law. Okay, and it confers the rights, or this provision confers rights on both citizens and foreigners, and the term person here is also includes legal person, that is statutory corporations, companies, registered societies, etc. Now equality before law. Equality before law is of British origin, or it is taken from British Constitution. Okay, British origin or British Constitution. So this equality before law, it implies, what does it imply or what does it connotes? Okay, no person is above the law. No person is above the law. That is, law is supreme. Okay, and equal subjection of all persons. Equal subjection of all persons to the ordinary law of land. Ordinary law of land administered by the ordinary law courts. Okay, so you are subjecting all persons equally, that is equal subjection of all persons to the ordinary law of land. Here you are mentioning ordinary law of land administered by the ordinary law courts, because since it is from the British origin. Okay, there the British Constitution is not a written constitution, and so the ordinary law of land is evolved from the administration of the courts. Okay, the court's decisions, okay, and orders. So equal subjection of all persons to the ordinary law of land administered by the ordinary courts. Absence of special privileges in favor of any person. Okay, there is absence of special privileges in favor of any person. So, rule of law implies three things. Okay, no person is above the law, equal subjection of all persons to the ordinary law of the land administered by ordinary law courts, and absence of special privileges. Okay, so this concept of rule of law is a negative connotation. Okay, why it is a negative connotation? It is a negative connotation because no person is above the law. That is, everyone is equal in the eye of the law, irrespective of his standing in the society. Okay, so irrespective of his standing in the society, the person is equal. That is, everyone is equal in the eye of a law, irrespective of his standing in the society. And also, absence of privileged class in the society. So that's why it's preventing the absence of privileged class, or it's stopping, there is no privileged class and everyone is equal irrespective of his standing in society. So that is why it is a negative connotation. Okay, so now what does this equality of law try to achieve? That is, legal or juristic equality. Okay, equality before law tries to achieve legal or juristic equality and also provides rule of law. Rule of law is implicit in our constitution under Article 14. Okay, so it aims or to achieve legal or juristic equality, and it also provides for rule of law, which is implicit in Article 14. So, Article 14 or rule of law. So, what is rule of law? Rule of law means lex supremus. That is, law is the highest authority of the land. Law is the highest authority of the land. Okay, and state or impose restrictions or on the use of arbitrary use of power of state, or restrictions or prevent the arbitrary use of power of state, and also impose limitations on the power of the state. Okay, so rule of law means lex supremus. It implies Law is the highest authority of the land, okay, and it prevents the arbitrary use of power of the state, and it imposes limitations on the power of the state. Why it is imposing limitations on the power of the state and restrictions on the arbitrary use? So that the rights of the individual are not suppressed, and it is the highest authority. Law is the highest authority, okay, so you have to follow the law. So this is rule of law. Now, rule of law, that is the concept of equality before law. The concept of equality before law is an element of rule of law, or is an element of the concept of rule of law given by A.V. Dicey, who is the British jurist. Okay, so the concept of equality before law is an element of the concept of rule of law. It was propounded by A.V. Dicey, who is a British jurist. Now, according to A.V. Dicey, the rule of law has three elements or aspects. What are the three elements or aspects? That is absence of arbitrary power. That is, when you say absence of arbitrary power, that is, no person shall be punished except for not following the law. Okay, no person shall be punished except for not following the law or breaking the law, or okay. So absence of arbitrary power and equal subjection. Same thing, equal subjection of all the persons to the ordinary land of law, ordinary law of the land that is administered by the ordinary courts. Last one, primacy of the rights of individuals. Okay. So primacy of the rights of the individuals means the constitution is the result of the rights of the individuals, okay, as defined and enforced by the courts of the law. Okay, so constitution is the result of the rights of the individuals as enforced or as defined and enforced by the courts of the law, rather than constitution being the source of the rights of the individual. Okay, so constitution is the source of the rights of the individual is Indian constitution. Okay, constitution is the result of rights of the individuals is the British constitution. Why? Because the British constitution is an unwritten constitution. Indian constitution is a written constitution, and since it is a written constitution, it is the supreme law of the land. So the rights of the individuals are, the constitution is a result of the rights of the individuals, that is, it is enforced or defined by the courts. Okay, so here, because of unwritten type of constitution, the courts, they are defining the rights of the individuals and they are enforcing them. So it has resulted in the provisions of the constitution. So according to Dicey, these are the three elements or aspects of rule of law. That is absence of arbitrary power. No person shall be punished except for breaking the law. Okay, and equal subjection of all the persons to the ordinary law of the land, subject to the ordinary or administered by the ordinary law courts. Okay, here when you are saying all persons, that is, whether he may be rich or poor, he may be an official or an unofficial, he may be of high or low class. Okay, so this is about all persons. Now the last is the primacy of the rights of the individuals. That is, the constitution is the result of the rights of the individuals, not the constitution as the source of the rights of the individual. Okay, so 1 and 2 they apply to India. 1 and 2 they apply to India, but the third one does not apply, because the third says the constitution is the result of the rights of the individuals, whereas in India it is the constitution is the source of the rights of the individual. Okay, so the rights of the individual are enshrined in the constitutions. Ours is a written constitution. Our constitution is a written constitution. Okay, so supreme law of the land, law of the land. Here, one more thing we have to understand is rule of law has changed. Rex lex into lex rex. That is, king is law to law is king. Okay, so rule of law has changed. Rex lex, that is king is law, to lex rex, that is law is king. So according to Dacey, there are 3 aspects of rule of law. That is, absence of arbitrary power, that is no person shall be punished except for the breach of law. Okay, except for the breach of law. Okay, equal subjection of all the persons to the ordinary law of the land administered by the ordinary courts. Third, primacy of the rights of the individuals. That is, the constitution is the result of rights of the individuals rather than the constitution being the source of the rights of the individuals. Okay, so 1 and 2 applies to India. Third one does not apply, because Indian constitution is the source of the rights of the individuals. So our constitution is a written constitution, whereas British constitution is an unwritten constitution. Since it is an unwritten constitution, the administration, that is the ordinary law of the land, has evolved by the administration of the ordinary courts, that is the decision of the courts, the judgment of the courts. Okay, so Indian constitution is a written constitution, it is the supreme law of the land. The rule of law has changed, that is, initially the king is the law, but the rule of law has changed it to law is the king. Okay, so this is about rule of law. Now, rule of law, Article 14, we have already discussed. Article 14, the rule of law is implicit. That is, equality before law and equal protection of law. So, the Supreme Court has ruled that rule of law is a part of basic structure of the Constitution. We have already discussed about basic structure of the Constitution in the previous class. Basic structure of the Constitution, okay, by Keshavananda Bharati case 1973. Okay, so basic structure are those principles. Okay, those principles which have the basic framework or essential structure or framework which cannot be changed. Okay, so the Supreme Court has ruled that rule of law is the basic structure of the Constitution. When the court rules it as basic structure of the Constitution, then this provision cannot be amended under Article 368. Under Article 368. Now let us try to understand the exceptions or let us try to understand the exceptions to the article equality before law. That is, immunities enjoyed by the president and governors of the state. Okay, that is under article 361. Privileges of the MPs and MLAs, article 105, article 194. Okay. Next, article 31C gives effect to the directive principles of the state policy. That is, the laws that implement the directive principles of the state policy under part 4 shall not be held violative of the constitution or shall not be void for the violation of article 14. Okay, so this promotes what? Directive principles of state policy promotes welfare state. Okay, so article 31A relates to the laws that implement the directive principles of the state policy under part 4, but these laws shall not be void if they violate article 14. Okay, and article 39B and article 39C. Article 39B relates to equitable distribution of resources of the community for common good. Equitable distribution of resources of the community for common good. And article 39C, prevention of concentration of wealth and means of production. Okay, so these two directive principles of the state policy, they cannot be challenged in the court of law for their violation of article 14. Okay, so these are the exceptions. Why they are not challenged? Because here we are equitably distributing the resources. Okay, here we are preventing the concentration of the wealth. How we are preventing the concentration of the wealth? By progressive. One of the way is progressive taxation. That is the higher income people, they paying more taxes. Okay, and these taxes are being collected and utilized for social welfare schemes. Okay, so article 39B and 39C. 39B deals with equitable distribution of the resources and article 39C deals with prevention of concentration of wealth of means and production. So these articles, they cannot be challenged in the court of law for their violation of article 14. Okay, so these are the exceptions. That is, immunities provided by the president and governors. Why the president and governors are provided immunity? Because of their constitutional status. That is, they cannot be imprisoned while in the office. The decisions taken by them in the office, they cannot be held accountable. Next, privileges of the MPs and MLAs, article 105 and 194. That is, while the session of the parliament is going on, an MP cannot be arrested. You should first intimate it to the speaker. Okay, same thing with MLAs. Okay. Next, Article 31C, giving effect to the directive principles of the state policy, and these laws, they cannot be held void if they violate Article 14. So these are the exceptions. Now let us come to equal protection of law. Equal protection of law is taken from American Constitution. Okay. Now what does equal protection of law implies? Equal protection of law implies equality of treatment under equal circumstances. Okay, so when the circumstances are equal, there should be equality of treatment. Okay. Next, application or similar application of the same laws to all the peoples, to all the persons under similar circumstances. Okay, so when you have similar circumstances, you have to apply same laws to all the persons, okay, in the same way. Okay. Next, likes to be treated likely, okay, without any discrimination. Okay. So similar people, likes means similar group of people or class of people should be treated similarly, okay, without any discrimination. So this is equal protection of law, that is taken from American Constitution. It implies equal treatment under equal circumstances and similar application of same laws to all the persons under similar circumstances. Likes to be treated likely without any discrimination. Okay, so same kind of people should be treated same without any discrimination. Now let us understand this in simple terms. Okay, so this principle, what it says? It says that application of equal laws under equal circumstances. Okay, so when the circumstances are equal, okay, similar circumstances, okay, then equal laws should be applied, or of equals to be treated equally. Now what are equal circumstances? Okay, equal or similar circumstances. Now whose duty it is? It is the duty of the government to create similar circumstances. Okay, it is the duty of the government to create similar or equal circumstances. Okay, or to bring all its subjects, that is to bring all the people under equal circumstances, that is similar circumstances. Okay, so if this equal circumstances does not prevail, if his equal circumstances does not prevail, that is equal circumstances in the sense egalitarian society, the state to welfare state, that is uplifting all the sections of the society, removing inequalities, okay, redistribution of resources, prevention of concentration of the wealth, okay. So if the equal or similar, if the equal or similar circumstances does not prevail, then the government can provide or can use positive discrimination to promote equal opportunities. Okay, so it is the duty of government. Under what we are saying that equal protection of the law in simple terms is application of equal laws under equal circumstances. Okay, circumstances is the conditions. Okay, so equals should be treated equally. Now whose duty it is to provide equal circumstances or similar circumstances? Government. Okay, the government should create or bring all its people or subjects under equal circumstances. But if it is unable to provide equal circumstances or similar circumstances are not provided, then the government can use positive discrimination towards a particular section, okay, and create equal opportunities. Okay, so this is about equal protection. Now, what are the examples? The examples are progressive taxation system and reservation policies of the government. Okay, by these two, that is progressive taxation system, you have already understood progressive taxation system, that is you are taxing more from high income groups, and by the money collected you are funding the social welfare schemes. Then reservation policies, that is you are providing reservations to particular sections, okay, such particular downtrodden sections, okay, SC, ST, OBCs, okay. So reservation policies of the government and progressive taxation systems, they promote affirmative action, that is positive action or positive discrimination, so as to bring about equality. So these promote affirmative action of the state, or this provides affirmative action. Ultimately, what is the goal? Ultimately, what is the goal? To achieve equality, legal equality. That is equality before law or equal protection of the law, or equal protection of law. So this is about equal protection of law. Now, what does Article 14 try to aim? That is equality before law and equal protection of the law tries to achieve equality of legal status. Equality of legal status, opportunities and justice. Yes, justice, equality before law. Okay, equality before law, you are trying to achieve justice, that is by saying absence of arbitrary power, that is equal subjection of all citizens to the ordinary law of land, okay, and also absence of privileges also, okay. So you are trying to achieve justice and also opportunities also. Just now we talked about equal protection of law. In that we talked about the duty of the government to provide similar circumstances. In case the similar circumstances are not, they don't prevail, then the government can positively discriminate and provide equal opportunities through affirmative action to promote equal protection of law. So equality of legal status, that is equality of before law. No person is above the law, that is everyone is equal in the eyes of the law. So this is about equal protection of law. Now the Supreme Court has held that when likes and unlikes are treated differently, then Article 14 does not apply. Okay, so Article 14 is about treating equals equally. Okay, now here you are treating equal likes and unlikes differently, or you can say equals unequals differently. Okay, so Article 14 does not apply. Now the Article 14, it forbids class legislation. That is the term class legislation describes laws that promote improper discrimination. That promotes improper discrimination. Okay, improper discrimination, that is by granting privileges to a specific group of people, and also by imposing liabilities on a specific group of people. Okay, so it prohibits class legislation, that is the term is used to describe laws that promote improper discrimination by granting privileges to a specific group of people and also imposing liabilities on a specific group of people. So it rejects class legislation, that is legislation for a particular class. Okay, so it violates Article 14. Promotes reasonable classification, that is the reasonable classification should be well established, it should be substantial and have genuine differences. Okay, so it promotes reasonable classification, and the reasonable classification should be well established, it should be substantial and promote genuine differences. Okay, and it should not single out a person or class of persons from others who are situated similarly. Okay, who are situated similarly. Okay, so Article 14, it forbids class legislation. Okay, class legislation is a term used to describe the laws that provide for improper discrimination by granting privileges to a particular group and also imposing liabilities on the particular group. This violates Article 14. So instead of class legislation, what we are promoting? What we are promoting? We are promoting we are promoting the classification, reasonable classification. Reasonable classification should be well established and it should be substantial and provide genuine differences, and it should not single out a person or a class of people from others who are similarly situated. Okay.